Do you know the top 10 things your condo association can and cannot do? If not, don't worry. You're not alone. But understanding these rights is crucial to your condo ownership experience. Hello, and welcome to the All About Condos channel, your go-to source for all things related to condos. Brought to you by Ickbens International Realty. I'm Octavio Rueda, your host and personal condo consultant, here to guide you effortlessly through the challenges of buying and owning and selling a condo. Owning a condo in Florida is more than just a place to call home. It's about knowing your legal rights and privileges as a unit owner and a member of your condo association. And trust me, you want to know them. The Florida Condominium Act, or Chapter 718 of the Florida Statute, it's like the Constitution, the highest law of condo associations. It defines everything from ownership, management, setting the standards for the developers, association, and owners like you. In this video, I'll share the top 10 mandates from this statute that define your rights as a condo owner. These are the non-negotiable mandates that your condo associations must follow and that you must know to truly maximize your condo ownership. So grab a notepad and let's dive right in. The condo statute requires for notice and holding meetings for the increase or collection of assessments and consideration of budgets at a condominium association to be properly noticed in advance to all unit owners. The notice of a meeting must include information about the assessments to be considered and must be delivered or transmitted to unit owners at least 14 days before the meeting. Meetings at which the annual budget is considered must be open to all unit owners, and if the budget requires assessments that exceed 115% of the previous fiscal year's assessments, a special meeting must be held if requested by at least 10% of unit owners eligible to vote. This special meeting must be held within 60 days of the adoption of the annual budget, and unit owners must be given at least 14 days notice of the meeting. The condo statute requires that major expenses, material alterations, or substantial additions at a condominium association not included in the reserve budget must be approved by a majority of the unit owners. Material alterations or substantial additions to the common elements or association property must be approved in accordance with the association's governing documents, and if no procedure is specified, by 75% of the total unit owners eligible to vote. Reserve funds and any interest accruing on them may be used only for authorized reserved expenditures unless their use for those purposes is approved in advance by a majority of unit owners or as specified in the association's governing documents. Unit owners have the right to attend and speak at all meetings of the Board of Directors, with two exceptions. These exceptions are meetings between the Board of Directors or a committee and the association's attorney with respect to the proposal or pending litigation if the meeting is held for the purpose of seeking or rendering legal advice, and meetings held for the purpose of discussing personnel matters. At any other meeting held by Board of Directors, unit owners may tape record or videotape the meeting and speak at the meeting. However, the association may adopt written, reasonable rules governing the frequency, duration, and manner of unit owners' statements. All decisions of the Board of Directors must be made at a duly noticed meeting and documented in the minutes. Adequate notice of the Board of Directors meetings, including a list of all the agenda items, must be posted conspicuously on the condominium property at least 48 hours before the meeting, except in emergencies. The Board of Directors must also adopt a rule designating a specific location on the condominium property for posting notices of Board of Directors meetings. If there's no such location, notices must be mailed, delivered, or transmitted electronically to each unit owner at least 14 days before the meeting. In addition to the physical location, the association may adopt a procedure for posting and repeatedly broadcasting the notice and agenda on a closed-circuit cable television system or website servicing the condominium association. The board of directors of a condominium association is limited to serving 8 consecutive terms. If a board member serves more than 8 consecutive years, they must be approved by a 2/3 vote of the unit owners in the election. The terms of all board members expire at the annual meeting, unless the bylaws state otherwise, or if all members' terms would otherwise expire but there are no candidates. If the number of candidates is equal to or greater than the number of vacancies, the candidates become board members upon the adjournment of the annual meeting. Any remaining vacancies must be filled by a majority vote of the newly constituted board. In a residential condominium association with more than 10 units, co-owners of a unit may not serve on the board at the same time unless they own more than 1 unit or there are not enough eligible candidates to fill the vacancy. If an alleged violation has been filed against a unit owner, the board of directors must provide at least 14 days written notice to the unit owner and any tenants, licensees, or invitees of the unit owner and offer an opportunity for a hearing before a committee of at least 3 members appointed by the board who are not officers, directors, or employees of the association or related to such individuals. The committee's role is to determine whether to confirm or reject any fines or suspensions imposed by the board. If the committee does not approve the proposed fine or suspension, it cannot be imposed. If the fine or suspension is approved, the unit owner and any tenant, licensees, or invitees must be notified in writing, and the fine payment is due within 5 days. Unit owners have the right to inspect and request copies of the association's financial and administrative records at any reasonable time. The association may, however, adopt reasonable rules regarding the frequency, time, location, notice, and manner of the record inspection and copying, but owners do not have to provide a reason or purpose for the inspection. If the association fails to provide the records within 10 working days after receiving the written request, it may be presumed to have willfully failed to comply, and the unit owner may be entitled to actual or minimum damages of $50 per calendar day for up to 10 days. If a unit owner is denied access to the official records, they may also be entitled to recover reasonable attorney's fees if they prevail in an enforcement action. The association is required to produce a financial report within 90 days after the end of the fiscal period, which must be made available to unit owners upon request. The report must be prepared in accordance with the generally accepted accounting principles, and the type of the report required depends on the association's total annual revenues. For example, associations with total revenues of less than $150,000 must produce a report of cash receipts and expenditures. Those with revenues between $300,000 and $500,000 must produce reviewed financial statements. And those with revenues of $500,000 or more must produce audited financial statements. The association is also required to provide unit owners with a summary of the association's reserves, including a good faith estimate of the total amount necessary to fully fund the reserve based on a straight line accounting method. Condominium associations with 150 or more units that do not contain any timeshare units must have a website or mobile application. This website or application must be accessible through the internet and must contain a subpage or protected location that is accessible to unit owners and association's employees. Upon a unit owner's request, the association must provide access to the protected sections of the website or application, which must contain digital copies of the association's official documents and their corresponding amendments, including the recorded declaration of condominium, the bylaws, the articles of incorporation or other documents creating the association, the rules and regulations, list of executory contracts, the annual budget and any proposed budgets, financial reports, certification of directors, contracts or transactions between the association and certain individuals or entities, notices of owner meetings and agendas, minutes of unit owners meetings, and any insurance policies. The website or application must also contain information on how unit owners can request copies of the official documents and access to the protected sections of the website or application. Condominium associations may not prohibit the installation of charging or fuel stations within the condominiums or in a unit owner's designated areas. However, the installations must avoid irreparable damage and be separately metered with costs borne by the unit owners, including installation, operation, maintenance, repair, removal, and compliance with any laws or regulations. Keep in mind, however, that associations may enforce payment, require adherence to safety and architectural standards, mandate the engagement of licensed firms, and necessitate insurance and reimbursement for increased premiums. The association also provides an implied easement for the installation and may establish charging stations on common elements or association property without constituting a material alteration. And there you have it, the 10 essential rights you should know as a condo owner and a member of your condo association. But before we conclude this video, there's one more essential thing I think you should know. The Department of Business and Professional Regulation is there to help you. In Florida, unit owners who encounter issues with their condo association's management of the finances, administrative responsibilities, or the day-to-day operation of the community can solicit the assistance of the DBPR to investigate and address the issue. The DBPR is the state agency that oversees condominium associations. Within the DBPR, the Division of Condominium, Timeshare, and Mobile Homes, known as the Division of Condominiums, is responsible for enforcing the Florida Condominium Act, which provides the legal framework for the operation of condominium associations in Florida. The Division of Condominiums also regulates community association managers like myself. Community association managers are licensed individuals who are responsible for managing the day-to-day operations of condominium associations. The Division of Condominium is responsible for disciplining community association managers who violate the state laws or rules. Owning a condo in Florida is both an exciting opportunity and a responsibility, complete with its unique legal considerations. By familiarizing yourself with the 10 essential rights I highlighted in the Florida Condominium Act, you're not just possessing a property, you're engaging in a community where your rights and privileges are clear. Whether you're new to condo ownership or have lived in one for years, understanding and actively exercising your rights ensures a harmonious living experience. Remember, owning a condo in Florida is more than a financial commitment. It's a lifestyle that requires awareness of your rights and engagement with your community. Thank you for joining us in this All About Condos channel. And feel free to reach out with any questions or comments. If you found this information helpful, please like or subscribe and share it with others who might benefit from this knowledge. Happy condo living in the Sunshine State. God bless.